Good morning, everybody. Happy Tuesday. Welcome to the Courtroom Files Live. We will start our day in Michigan with Judge Dad.
You gonna stop or?
I have insurance.
Let me see it.
I don't have it with me, but
Where is it?
It's in the car. I got pulled over for impeding traffic.
I know you
Not
did.
insurance.
I know you did, but you got no
That's
proof.
all old stuff.
I can read. I get it. Okay? You got a slew of them on here though.
I understand that.
You're gonna plead to impeding?
Correct.
To that charge, responsible or not responsible?
Responsible.
All right, please accept it. 170 cash, you're into the hall chief. You're all set. Good luck. Zwolensky, Marley Marie Zwolensky. 25T645381. Good morning. Your name?
Marley Zwolensky.
All right, you're gonna plead to impeding, right?
Yes.
Responsible or not responsible to that?
Responsible.
Please accept it. 150. Original charge dismissed. Good luck. Bernard John Mashowitz, 25T645689. Your name?
Regarding that, what's?
All right, so you're gonna plead to impeding traffic, right?
Right.
Responsible or not responsible?
Responsible.
All right, I'll accept the plea. 160 is your total. Cash your end of the hall.
Okay.
Good luck.
Thank you.
Dylan James Goins, 25T645490, A and B. Your name?
Dylan Goins.
They say you're gonna plead to 10 over on file A, which is 2 points, and they're going to dismiss file B. Is that what you want to do?
Yes, sir.
What do you do for a living?
I'm a diesel mechanic.
I thought you were a NASCAR driver, the way I'm looking at this. You go 90 and a 50?
I just had pulled the motorcycle out the first time. It was a stupid mistake.
It's pretty heavy. All right. For the charge of 10 over, that would be 60 and a 50. Responsible or not responsible?
Responsible.
All right, I'll accept that plea. I'm gonna dismiss file B. 185 is your total. Slow down, please,
Yes.
okay? All right, good luck.
Thank you, sir.
Nicholas J. Horn, 25C704225FY. Good morning, sir.
Good morning, Your Honor.
Your name?
This one.
I have two show causes. I need to check these here. You've got, I don't know why I have two. All right, well, you got 4 counts. I'm gonna arraign you and then I'll be glad to give you a lawyer, okay?
Sure.
You have 1 prior technical violation. There's 4 technical violations alleged here. They think that on count 1, that you failed to refrain from consuming alcohol or drugs, testing positive for THC on April 7 of 25. That is 1 charge. Do you understand the charge?
Yes, Your Honor.
Count 2 alleges that on April 22nd that you tested positive for THC. Do you understand the charge?
Yes, Your Honor.
Count 3 alleges that you tested positive for THC on May the 5th of 25. Do you understand the charge?
Yes, Your Honor.
And count 4 alleges that you tested positive for THC on May the 20th. Do you understand the charge? That would be 4 technical violations. If you plead guilty or if you were found guilty of those, you could be incarcerated for, I'm just telling you, this is the possible penalty. You have a disorderly and attempted resist and obstruct. Attempted resist and obstruct is a 1 year. I'm just telling you, you could have your probation revoked and you could be incarcerated for up to 365 days. Do you understand that?
Yes, Your Honor.
And did you sign, read, and understand the advice of rights?
I did.
If you plead guilty, you'll be giving up all those rights and there will not be a hearing or a trial. Do you understand that?
I understand.
I'm gonna enter a not guilty plea. I'm gonna get you a lawyer. We're going to have a revocation hearing and go talk to the lawyer. And then when he or she is ready, I'm not sure who is doing it today. You'll come back in here with your lawyer, okay?
Thank you, Your Honor.
All right, so you can just go out in the hallway, not guilty, pleas entered, and we'll go from there. Thank you. First, let me get these two out of here. Christina Lynn Drew, 25T645428. Vladichuk, have a seat at the table, please. Good morning, ma'am. How are you?
Your Honor.
Your name?
Christina Drew.
All right, so you got to take care of these things quicker, okay?
I was sick and forgot.
Okay.
And
How much money do you have today?
I have none. I'm on disability.
Okay.
At the beginning of the month, I can make $50 payments.
Okay. Okay. What day do you get your check, ma'am?
On the 3rd. I was coming back from the pharmacy. I had pneumonia. And that's why I totally forgot. I was sick on my birthday and everything. I didn't even realize that my plate had expired and I was coming back from the
Did you
pharmacy.
get another one?
Huh?
Did you get another plate?
Oh, yeah, as soon as I got better, I went right up and I got a plate. My license was even expired. I didn't even know my license was expired.
And you got that too?
Oh, yeah. Right away, as soon as I got better, I did. I even showed the police officer. I said, look, and I had a whole big bag of prescriptions. I was like, look, officer, I'm coming from the pharmacy. He's like, I'm sorry, you got, it's,
All right, here's what I'll do. You pay 50 per month beginning July 7th.
okay,
I'll reduce your fines. I'll give you a break. I'll reduce it to 135. It's at 165, okay?
all right, I appreciate
The
it. sir.
7th of every month. Now, if you need more time, all you have to do is call the court. We'll go on Zoom on or before the due date, or you come in here and talk to me on or before the due date, 8:30. I don't care how many times we have to do it. Just don't ignore me, okay? I'll give you an
I will.
extension.
Thank you.
Good luck to you, man.
Thank you so much. Have a blessed day.
You too. Thank you. Vladichuk?
Hello.
Sophia Grace Vladichuk.
Yeah.
25T645289. Who's this, your brother?
That's my name.
Oh, your name, ma'am? Just kidding.
Oh, Sophia Elijah.
All right, just relax. This is not the end of the world here. So your name, thanks for coming with her, by the way. What's your name?
Walter Elijah.
All right, you're gonna be careful though, right? You're a new driver,
Yeah.
relatively, so you're gonna plead to impeding traffic, right? Yes? Okay, to that charge, do you plead responsible?
Responsible.
All right. What are you, a senior?
Yeah.
What are you doing next year?
I'm going to Michigan.
Good for you. Congratulations. You must have done well in school. A lot smarter than me, John. Huh? $150. Good luck. What are you gonna study?
Biochemistry.
Okay, good. So you're not going to law school so you can run against me then, right? Take care. Have a good day. Thank you. Good luck. And sir, really, thank you for coming. John Michael Trupiano, 25W838758. Mr. Boulahanis, I'm going to be right with you. I'm going to get two of these informals out of here and I'll be right there. Your name?
John Trupiano.
How you doing?
Good, how are you, sir?
Good. You're going to plead to impeding, right? Responsible or not responsible to that?
Responsible.
Okay, let's see, this was issued. You got another one of these. You had an accident a week before. You got to be careful, right?
Yes, sir.
All right,
I've been having tickets in 50 years and
please accept it. 165 is your total, okay? Original charge dismissed. You can go down to the cashier. Good luck.
okay, thank you.
You're welcome. James Adrian Basham, 25T645688. How you doing, sir? Your name?
James Basham.
You're going to plead to impeding, right? Responsible or not responsible? Please accept it. 150. Cashier end of the hall to your right. You're all set. Good luck. Where's that? Miller. Okay. People against Lindsay Nicole Miller. 25W8386528 and C. All right. Good morning, Mr. Bulahanis. Your appearance?
Good morning, Your Honor. Greg Bulahanis, P 36431 on behalf of Lindsay Miller.
Your name, ma'am?
Lindsay Miller?
All right, so your client previously pled guilty to operating while impaired. The super drunk charge was dismissed, and the open intox was dismissed. And I was told that she had insurance, she'd acquired it after the fact, but she did plead responsible to no proof of insurance as well. Is
Correct,
that
Your
accurate?
Yes.
All right. Have you had a chance to review the report, and are there any material additions, corrections, or deletions?
Your Honor, it did say that she was single in the report. She's married. Other than that, it's factually accurate. And we'd ask the court to adopt the recommendation by the probation department.
Ma'am, anything you would like to say?
No, sir.
So this really does concern me at a really high, I mean, it's 2.5 times the legal limit or better. So you got to be careful, okay? 15 months probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. I'll go 13 months probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify the probation department. You have to report as directed. No alcohol, no illegal drugs, no marijuana. You're not to purchase, possess, or consume any one of those. You're to submit to chemical testing, PBTs and ETGs as follows. I'm gonna make those weekly for 3 months. If you're clean, I'll revert it to bi-weekly for 3 months. If you're clean, I'll make it monthly. Kratom poppy seeds and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. You're to attend outpatient treatment. You're to attend the Victims Impact Panel. You're to attend AA twice a week until you are in the treatment program. Mr. Bulahanis, have you seen her AA verification this morning to verify that?
1 second, Your Honor, did you bring her? Oh, 1 second, Your Honor, I'm sorry. She did show it to me before. Yes.
Okay, so she's been
Yeah,
going
twice a week.
since I ordered on May 28th, correct?
Yeah, yes, twice a week, Your Honor.
I'm sorry, I didn't hear you.
She's been going twice a week, yes, sir.
Okay, good enough. So twice a week until an outpatient. If you get an outpatient treatment this week, you don't have to go to AA or NA, and then attend the Victims Impact Panel as well. 4 days jail credit, 1 serve 3. I'll let you serve those as follows. 2 days on the court work program. There's a $35 charge for that per day, and 1 day or 8 hours of community service, and I'll let you complete that. I'll give you all the way until August 1 to complete that, okay? Fines are $300, costs are $225, $75 victims' rights fee, $50 justice assessment for $650, probation fees are $260 for 910, screening fees $60 for 970, $1,040 including the court work program fees, and you also have $150 in costs of recovery. Your total is $1,190. If you violate, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal. You have 14 days to apply for a court-appointed lawyer for purposes of appeal. You may be eligible for early discharge, so you can actually get off probation in 6.5 months if you complete everything and there are no violations within the preceding 90 days. So you can mark your calendar. You could be off by sometime around Christmas if you're compliant here, okay? Make sure you do everything too. You have 21 days to appeal, again, 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you have any questions at all, ma'am?
No, sir.
All right, can she pay all of this today, or does she need time, Mr. Bulahanis?
Judge, there's a C case.
Oh, thank you. Thank you. I already wrote it down, but 125 on the no proof of insurance. Thanks, Lisa. So I'll cut that down a little. So she owes $1,315. Could she pay all of that today?
She can't pay it all today, Your Honor. If you give her 30 days, it can be paid in 30 days.
How much can she pay today?
$200, Your Honor, today, and the balance in 30 days.
All right, you pay the no proof insurance today. You'll save yourself a couple of dollars if you stop by the courthouse here. Where does she live? She lives in Taylor. It's up to you. You pay $75 today, okay, on
Wait a
the
minute, how much, I'm sorry, how much do you want her to pay today, Your Honor?
125 on the no proof insurance,
Okay,
$75 now on the impaired driving.
okay.
How's she gonna pay this all in 30 days? She only makes 150 to 350 a
Her,
week, she
her
said.
husband's gonna assist her with the, payment, Your Honor.
All right, well, I'm just gonna say you pay $75 down and you pay $200 weekly, and I'll start that beginning on June the 20th, okay?
That's
If you
fine, Your
don't
Honor.
have the money on any one of those dates, ma'am, you call the court, we'll go on Zoom, or you come in here on or before the due date, and I'll give you an extension. So when you come up to make your payment, you should go meet with probation and they will instruct you, all right?
Did you want her to go today, Your Honor, to probation?
She really should, yes. If there's something pressing where she can't, you tell me.
You go today? Yes, Your Honor.
She's gonna come up here today? Okay, good enough. Have a good day, ma'am. Thank you.
Thank you.
Thanks, Mr.
Your
Lewis.
Honor.
Lynn Marie Brown.
All right, good morning once again, everybody. Welcome to the Courtroom Files Live. Happy Tuesday. Good to have you here. We have a special guest in the studio today. Mrs. The Courtroom Files is off camera, but later on she might pick up her mic and make a comment or two. But if you see Beth Soul in the chat, that is Mrs. TCF. Let's go to Wisconsin. We'll cross Lake Michigan, and we'll say good morning to Judge Mogan.
By this Friday. Mr. Marlowe, we'll go through the initial hearing today. You can enter you wouldn't necessarily even need to enter not guilty plea, because then we have to set up that next hearing, which is the preliminary hearing. At that time is when you would need your attorney. And as I stated off the record, if this next date doesn't work for whatever attorney you retain, they can contact my assistant and you can have it moved to a different date and time. And we went over the fact of that you can waive time limits for that next hearing to have more time to be able to retain an attorney. And so you understand all of that?
Yes, ma'am.
And so you were served a copy of the criminal complaint, and it has one count. It alleges operating a motor vehicle while under the influence, 7th, 8th, or 9th offense. It alleges on or around April 11th, 2025, in Burnett County, Wisconsin, you operated a motor vehicle while under the influence of an intoxicant. That is a Class F felony. Upon conviction, you could be fined up to $25,000 or imprisoned up to 12.5 years or both. Plus, due to the severity of this offense, if you don't have the ability to have other things like collateral attacks, etc., which you'll talk to your attorney about. If you are convicted of this offense, 7th, 8th, or 9th, there is a mandatory minimum of the bifurcated sentence of the incarcerated part of that sentence. The mandatory minimum would be not less than 3 years of incarceration in prison, and then there could be the extended supervision portion after. So this is a very serious matter. So the court understands that and will give you time if you wish to waive the time limits for the next hearing. Is that what you wish to do?
Yes, ma'am.
All right. So what I'm going to do is I'll set this for some time in the future. Hopefully you're going to be able to locate and retain your attorney, and hopefully this next date works.
So then, like you said, I apologize, I didn't mean to interrupt or whatever,
That's fine.
speak out of turn. But like when I find an attorney, get him paid, if that doesn't jive with him, then like you said, he can just get a hold of you guys and,
Yep, you'll call my
All right.
assistant
All right.
and it'll be fine, because you're waiving time limits and so you'll have ample time to be able to
thank you.
get it in. And I'm gonna tell you right now that with my calendar this summer, the next available date I could have it anyway, would be August 11th at 3.
Okay.
Okay, so August 11th at 3, you can come up here and get your notice, and then you'll have the date so you can talk to your attorney, whatever attorney you
Right.
retain. Okay?
Yep.
All right, so come get your notice and you're
Okay.
free to go.
Did the court set the prelim for August 11th or? a status?
Yes, prelim. not nice yet. It's gonna be nice. I know, the next 2 days are gonna be nice and then rain, rain, rain. But I think we need it.
I feel kind of conducive to the hockey game. I try my best. Y'all have a good day.
You too. Mr. Harrington?
Morning, Judge.
Good morning. We will go on the record in the matters 24 CM 120, 25 CF 04, State of Wisconsin versus Latrell Paffel. The state appears through District Attorney Kevin Schmidt in person. We have Defense Counsel Eugene Harrington in person. Mr. Paffel appears by video conferencing in custody in Burnett County Jail. We're set today in these matters for status conferences. I believe that Mr. Paffel was in the process of being revoked or sitting his revocation period. And the parties were discussing a potential resolution of these cases. Mr. Harrington, can you please update the court?
Yes, Judge, I made a proposal to Mr. Schmidt before I went back fishing. Mr. Schmidt and I had a brief conversation this morning for various reasons, which I appreciate Mr. Schmidt's taking this position. He cannot accept the proposal that I made, so I need to go back and study the crimes a little bit and see if we can come to something other than what's there. I think we're going to resolve it, but
Just need
Well,
some
right.
time. And I believe Mr. Paffel is sitting his revocation and it's early fall when he is released.
I think it's August or September, Mr. Paffel. That's when your revocation is done,
September 11th.
September 11th.
All right, so let's see. We can get a date and time. August 18th, can you do 11:45?
Brief second, Judge. August 18th, I cannot.
We cannot. Would you be able to do August 12th at 10:45?
Yes.
All right, August 12th at 10:45. We will have a status in this case.
That we're able to resolve it by then. Is there time for a plea that day?
If you would like, I can do that. So let's schedule it for that, for a plea then that date. And that's only a misdemeanor plea, so I don't know if there's a
No.
potential felony.
Mr. Schmidt is not going to agree to a misdemeanor dismissal.
All right, so
I'd like him to, but he represents the state. I represent the defendant, and
all right, well, then we can schedule that. We'll just schedule it for a potential plea.
okay.
I'm gonna do the full length.
Do what?
I'm gonna do the full length.
Yes, please. And then we'll just go from there.
I'll let you know early on whether it's going to be a plea or not, though, Judge.
That sounds good. Okay, thank you.
Thank you.
All
So I'll
right.
be up to see you in a little bit.
All right.
All right, we'll see you then. We will go on the record in the matter 24 CF 196, State of Wisconsin versus Brian Roseland Jr. Oops, I need Mr. Marco. Oh, and it's, okay. We will go on the record in the matter 24 CF 196, State of Wisconsin versus Brian Roseland Jr. The state appears through Special Prosecutor Aaron Markle by video conferencing with approval of the court. We have Defense Counsel Eugene Harrington in person. Mr. Roseland appears by video conferencing in custody in Burnett County Jail. We're set here today in this matter for a status conference. Mr. Harrington, can you please update the court?
Judge, I also filed a petition to modify bail. As I recall correctly, Mr. Marco and I agree that the petition is appropriate. It's conditioned upon Brian entering substance abuse program, Minnesota Adult and Teen Challenge. He has been admitted. The cost to be paid for by Mille Indian Tribal Services and Minnesota Department of Health and Human Services. He would be picked up at the jail, transported to the facility. He will waive extradition. The agreement is that if he successfully completes phase 1 of that program, the district attorney will amend or accept a plea to possession of methamphetamine.
I'm gonna need a real reason as to why that's in the public interest.
Cross that bridge when we get to it, I think,
Well,
Judge.
we are here when we get to it, because I'm not agreeing to going to Teen Challenge. We have two very serious, I'm glad that the defense and the state are in an agreement with that, but it still has to meet my muster. And I have 2 counts of manufacturing, delivering methamphetamine, greater than 10, but less than 50.
Judge, I'm not
Class
prepared.
D.
I'm not prepared to satisfy the court's concerns today. I would request that we set this for a status as soon as possible so that we can
Have a
readdress
full-
the issue.
That sounds appropriate. Because I have 2 very serious allegations, 2 very serious charges. We went through the preliminary hearing stage. I found probable cause. And I'm going to tell you, and I'm going to say this again, that treatment isn't a get out of jail free card. But unfortunately, my next available date is your August 11th. That's it. Unless I have a trial go away.
What time, Judge?
I can do,
August 11th or 12th?
when you were coming back, August 12th. Okay. I scheduled you for August 12th at 11 or at 10:45.
10:45.
All right, then I could do at 10:30. August 12th at 10:30. If something else opens up before then, we can have the hearing, but I need to know if that works with Mr. Marco.
It will. It looks like I also have you at about 2 p.m. with Deborah Chapman that day, so.
Oh, 2 p.m. that day? Well,
Yeah,
I guess Mr. Harrington will be here already in that morning. So,
And I'm available then too, so that's fine.
and are you okay with the state appearing by video?
Yes.
All right. So we'll see you August 12th at 10:30. August 12th at 10:30. We are adjourned. Thank you.
You.
Alrighty, folks, let's head west to Judge West, because Judge West is the best, and when she brushes her teeth, she likes to use Crest. I'll hold my other rhymes close to the vest.
Here we go.
Mr. Bordeaux, you're charged with the second-degree felony offense of robbery, and that's from March 18th of 2025, and that's cause number 250444. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them, that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 10-year deferred probation. There would be a $500 fine, and then we would wait for the PSI and see if there was any type of recommendation for safe P or treatment, and then I would make that determination. Is that your understanding? Also, do you understand, if you are not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Bordeaux is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent, you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. Then we'll come back at a later date for sentencing. All right, thank you, sir. You can go back with the bailiff. Yes, sir, thank you. Oh. Okay. Mr. Nix?
Yes, Your Honor.
You've got Michelle LaChasse.
Yes, Your Honor.
That's all that stuff. Good morning.
Good morning. How are you, Judge?
Good. Good morning. Good morning, ma'am. Are you Michelle LaChasse? And this is cause number 22-39304. Ms. LaChasse is on probation for abandoning or endangering a child. It's a state jail felony. That probation was for a 3-year deferred probation, October 17th of 2022. Has that been extended? Okay. So obviously, we'll see what we do today, but if there's going to be safety, I think that would be a requirement for me to do that. So I received an administrative hearing on April 30th from Mr. Ruiz with some issues that have been going on with regard to Ms. LaChasse allegedly going to the Sky Bar Lounge, failing to adhere to the curfew, failing to adhere to mental health services and treatment plans, remaining compliant with medication, admitting to drinking, and also admitting to trying to locate drugs as well. That hearing recommendation was to continue supervision and request SafeP, which was agreed at the time by Ms. LaChasse. I signed off on that and ordered it. Mr. Nix has filed a motion asking that I reconsider that. I have asked probation for kind of an update in their response to that, as well as the state, who said pretty much it's up to me and probation and everything else. So it's my understanding, Mr. Nix, that Ms. LaChasse is wanting to do some kind of local inpatient treatment.
So Your Honor, if I could briefly just kind of give a little bit of a recap. She had her medication switched on March 11th and March the 20th. And shortly after that, if I can present this, I've shown a copy to the district attorney's office this morning. It showed that they made a major medication change, took her off Seroquel, put her on Prozac. She immediately started having issues with the Prozac. She's still having issues with the Prozac. She's taking the Prozac at the jail. They're giving it to her. She's having issues. What we've done is we've spoke to Baptist hospitals. I have her mother and I have her fiance here. We have documentation that she would be accepted into inpatient at Baptist Hospital. Also have a letter from her doctor.
But that's just a 5 to 7 days.
No, they can actually keep her inpatient for up to 30 days, Judge, and then they have an outpatient program that could continue after that. If I could present this is a letter from her doctor that kind of underlines her very exacerbated issues. What I'm asking the court to do is not to exactly undo the SafeP. What I'm asking the court to do is hold the SafeP in abeyance, give her a chance to do the inpatient Baptist, make sure that she's on the right medication. I presume that a major medication change is about to take place due to the fact that she's having such issues with the Prozac, and we reconvene after she's completed an inpatient stay, whether it be 14 days, whether it be 30 days. I'm assuming it'll be 30 days based on what the fiance's talked to with Baptist. It would come at no cost to the taxpayer or to probation. We've already cleared it with her insurance. She's stayed there before, and insurance covered almost 100%. I'm asking the court to just hold the SafeP in abeyance until she can do the inpatient treatment. We reconvene in 30 days and see how she did in the inpatient treatment.
And then depending on how the reports go, how everything that I turn over from her inpatient stay to both probation, the state, and the court, you decide if safety is still in her actual best interest at this point. We understand that safety is also a blessing. She could have been sentenced to state jail time. We're not underscoring the issues. We're explaining to the court that this is a mental health issue caused by a major medication change that's documented. Her issues follow immediately after this, and she's still on the Prozac, and she's still having lots of problems in the jail on the Prozac. We're asking that we just hold this in abeyance. I'm not asking the court to undo it, take it away, put her back on regular probation. I'm not asking for that. I'm asking to hold it in abeyance, place her, allow her to be placed in the inpatient.
But we don't, do we know, is it up to the hospital how long she stays?
I believe so, Your
I can't
Honor.
order some
Correct.
certain amount of
Correct.
time.
And however long that is, if the court feels that it's not long enough, we can reconvene and I can show you the records at that point and we can make a decision from there. But Baptist has told the family that it would be up to 30 days and then they have an outpatient treatment that can continue after that. Now, of course, we won't know if that's appropriate until we see how she does in there, but it's pretty clear that this is a medication change that caused this behavior.
Mr. Nichols?
Judge, the main hesitation on our part is that she agreed to safety and now wants to do things on her terms. I think safety is where she needs to be based on the relapse and the violation she had. And I want to bring the court's attention, when she was first put on probation in 2022, she was ordered ISF. Didn't want to go, went to a private inpatient program in Harris County, which she was discharged unsuccessfully from. So it's almost like we're rewinding the same script as before, and it obviously didn't work then.
I didn't see that.
I don't think it's contained in the admin. I think Mr. Ruiz can testify to that, though, Your Honor, if you want more detail. He informed me about that this morning.
Okay. Do you have any disagreement with regard to what happened at the beginning of probation that they're talking about, Mr. Nix?
I'm not sure that I was a part of that, so I don't know that I can speak to that. What I can speak to is that they made a major medication change that immediately caused these issues. SafeP is a wonderful program that's helped a lot of people. I don't know that it's fine-tuned for her mental health issues that are causing the issues right now. I think it's a fantastic program, and I still think she might end up there, but I think if we get her the right mental health treatment and get her on the right medication, she's much more likely to be successful in SafeP if she has the right medication and she is of the right frame of mind.
The special needs SafeP facility, do they adjust medications and things like that? Yeah. I think based on what I know now from the beginning that I ordered or agreed or whatever happened with ISF, and then agreed to allow her not to do what everybody else thought was appropriate, go to her own choice, and successfully discharged from that, and here we are having the same problem. So I'm not going to adjust that order.
Yes, ma'am.
I am going to order the special needs. It's special needs safety. It's not the regular one. It is, the whole purpose of it is to treat both things. And so that can all take place there, and I think that would be better for her and for our community. In addition, I am going to, because of the issues in the administrative hearing, the fact that a motion hasn't been filed, the length of time, I think, obviously is an issue. And so I am going to also at this time order that Ms. LaChasse's probation be extended by 2 years. That should give plenty of time to get through the program, get through aftercare, make sure everything is going like it should be, and then hopefully get off this probation without a conviction or going to state jail. All right, I know it's not what you want. I hope you take advantage of it. However, it's a good program. You can talk to them about medications and get stabilized before you get out and get on aftercare. Okay, thank you, Mr.
Thank you,
Nix.
Judge.
Thank you, Mr. Ruiz, for being here as well. There's really not I think all that's probably can be thrown.
All right, I think we'll go ahead and hold Judge West's court in abeyance for the moment. Let's go to Judge Middleton. I also have eyes on Judge Boyd's court. She's going to have closing arguments for a trial they were doing, and we'll probably go to that when it happens, but it hasn't happened yet. In the meantime, let's go to Michigan and say good morning to Judge Middleton.
Good morning, Miss Adams. We've met, but you're Shanta Lachelle Adams? Shante, and you told me that last time, so again, I apologize. Shante Lachelle Adams. Ms. Adams is here with her lawyer, Mr. Paul Gibson. She's charged with 3 counts of resisting obstructing a police officer, Deputy Kevin Penn, Deputy Zach Radke, I guess 2 counts, as a second offender. She had a previous RNO as an attempt in 2021. So it's punishable by a maximum 3 years imprisonment. Deputy Penn and Deputy Radke are both fine officers with the Sheriff's Department. Mr. Joshua Robert is here and indicated the prosecutor would again dismiss the felony charge for a plea to attempting to resist or obstruct a police officer. Is that correct, Mr. Robert?
That's correct.
You agree with that, Mr. Gibson?
Yes, Your Honor.
Ms. Adams, attempting to resist or obstruct a police officer is a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000. Mr. Gibson indicated you wish to enter this plea by way of no contest. By pleading no contest, you don't admit what happened, but you also don't deny what happened, and you would allow or accept that a conviction would enter. Do you understand?
Yes, sir.
And Mr. Robert, is a no contest acceptable?
Yeah, no objection.
It appears from the bond information report, you were either intoxicated, high, or in some sort of a mental episode and basically out of control. Do you not have a clear memory of this?
I remember bits and parts.
All right, that's a legitimate reason for a no contest plea. And we might as well tell everybody all at once, all 7 of you, that if you're here and you're going to enter a plea to a criminal charge, you're going to give up your right to have a trial in front of a judge or jury. If you had a trial, you'd have the right to be represented by an attorney. Mr. Gibson is here. You could also hire an attorney of your own choosing if you wished. Mr. Gibson was appointed by the court at your request. If you had a trial, you'd have the right to take the witness stand and testify on your own behalf. But you don't have to, because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. Do you understand?
Yes, sir.
Now, when you plead no contest, I'll get the factual basis from something else. In this case, I'm going to use a bond information report that was prepared by Deputy Radke. Is that acceptable, Mr. Gibson?
Yes, Your Honor.
All right, on May 28th, deputies were dispatched to 205 West Baroque Street, which is where you live here in Centerville.
Yes.
Are you still there?
Yes.
Shanta was making suicidal statements. On scene, Adams Shante refused to obey commands. Deputies had to physically restrain her multiple times to make her comply. At one point, Adams screamed and ran at the deputies. She was taken to the ground, where she did not comply with orders and resisted handcuffing. She was uncompliant walking to the cruiser, and it took 2 deputies to force her into the back seat. At the hospital, Adams continued to try to get past deputies and security. They had to physically push her back into the room several times. She was cleared by hospital staff and lodged for resisting obstructing. Your preliminary breath test was 0.156 when they booked you in at the jail. You were probably more intoxicated than that. So I think alcohol is a very large contributing factor to this. And this is like deja vu all over again from the earlier case we did a couple of years ago. I'm gonna want to get more information before I do the sentence. Possibly even a pre-sentence. Let's talk about that. Miss Adams, you're back living at your address here in town. Are you connected with Pivotal or anyone else for any services?
Yeah, I had an appointment last Thursday with my therapist.
I think I'm gonna get a pre-sentence. Who was your probation officer last time?
I've never been on probation.
I thought you were. Let me look.
As a child, I was, but not as an adult.
You were working back then. Are you working now?
No, I took a month off for my mental health.
All right, where were you working?
Midwest Tool.
Are you on probation or parole anywhere else?
No.
Well, let's see if we can find a place to put this out a bit. Things get a little tricky at this time of year with vacations and court conferences. Are you available on Monday, July 14th for a sentence?
I think so.
Well, we'll make sure, but Mr. Gibson.
Oh, okay. Let's see.
Well, it's good. At what time?
10:30.
It looks like I've got status conferences that start at 9, so as long as they're done by then, I don't have written down what time they end, but so I don't know if 11 o'clock's open, but
All right, let's set it for 11. I'm gonna get a pre-sentence report. She already had an R&O, there's alcohol issues, there's mental health issues, juvenile issues. Oops. That'd be 7/14/25. Bastille Day. All right, Ms. Adams, I'd like you to take this. I'm gonna get some more information in terms of a police report, any medical reports you'd like me to see. I'm gonna have the probation department prepare a pre-sentence evaluation to give me some help on it, figure out what to do here. Last time I gave you a couple days, actually Judge Pattison did a couple days in jail and a fine, which you paid. But this probably was bad. I may also want to see the video if possible. Or you go out to the counter, they'll give you a time and date to come back and meet with the probation department. All right, you're good to go. William Donathan? Is he in jail? William Donathan?
the one that has a
So Judge Boyd is going to do closing arguments here shortly on a trial she's been conducting for the last couple of days. They're still getting that ready to go. In the meantime, I'm just going to hang with Judge Middleton. We're going to show this at the request of Bailey, who's a channel member who's been following the trial. But Bailey, if you could do us a favor in the chat and just throw in a summary of this case so people have a little bit of context, I'd surely appreciate that, and I know the viewers would too. And we'll cut to there as soon as they get that rolling. So we might cut away in the middle of Judge Middleton, but just so y'all know what I'm doing.
Keep plugging away. Every case is different and every case deserves careful attention, which means it sometimes takes us a while. Are you Heather Nicole Straight?
Okay, it looks like she's off and running, so we're going to go ahead and cut over there. Also here in the studio with me today, I have a special guest, Mrs. TCF. Beth is here, not on camera, but on mic. Beth, you want to say hi to everybody?
Hi.
So she's here watching what we do, participating in the chat, stuff like that. So feel free to say good morning to her if you'd like. And let's go to Judge Boyd's court, and we'll ride these closing arguments for a while.
Rodriguez stands charged in count 2 of the indictment with the offense of indecency with a child by sexual contact alleged to have been committed on or about the 14th day of November 2014 in Bexar County, Texas. The defendant, Alexander Rodriguez, stands charged in count 3 of the indictment with the offense of indecency with a child by sexual contact alleged to have been committed on or about the 15th day of November 2015 in Bexar County, Texas. To all of these offenses, the defendant has pled not guilty. 1, our law provides that a person commits the offense of continuous sexual abuse of a young child if during a period that is 30 or more days in duration, the person commits 2 or more acts of sexual abuse, and at the time of the commission of each of the acts of sexual abuse, the actor is 17 years of age or older, and the victim is a child younger than 14 years of age. Just one moment. We have a new court reporter. Here's the copy. Number 2, an act of sexual abuse means any act that is in violation of the penal law prohibiting aggravated sexual assault of a child under section 22.021 of the Texas Penal Code, and indecency with a child under section 21.11A1 of the Texas Penal Code if the actor committed the offense in a manner other than by touching, including touching through clothing, the breasts of a child. 3, child means a person younger than 17 years of age. 4, Texas Penal Code section 22.021 provides that a person commits the offense of aggravated sexual assault of a child if the person intentionally or knowingly causes the penetration of the anus of a child by any means or causes the anus of a child to contact the sexual organ of another person, including the actor, and if the victim is a child younger than 14 years of age at the time of the offense. 5, our law provides that a person commits the offense of indecency with a child by sexual contact if, with a child younger than 17 years of age, the person engages in sexual contact with the child or causes the child to engage in sexual contact. Sexual contact means the following acts if committed with the intent to arouse or gratify the sexual desire of any person. Any touching by a person, including touching through clothing of the breasts of a child, or any touching by a person, including touching through the clothing of any part of the genitals of a child, or any touching of any part of the body of a child, including touching through clothing with any part of the genitals of a person. 6, a person acts intentionally or with intent with respect to the nature of his conduct or to the result of his conduct when it is his conscious objective or desire to engage in the conduct or cause the result. A person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. 7, our law provides that the time of the offense alleged in the indictment must be some date anterior to the presentment of the indictment and not so remote that the prosecution of the offense is barred by limitation. The indictment in this case was filed on June 18th, 2024. There's no limitation period for the offenses of continuous sexual abuse of a young child, aggravated sexual assault of a child, and indecency with a child by sexual contact. The phrase on or about means that the state is not required to prove that the alleged offense happened on the exact date alleged. With regards to count 1, even though you are not required to agree unanimously on which specific alleged acts of sexual abuse were committed by the defendant or the exact date when those alleged acts were committed, if they were, in order to find the defendant guilty of the offense of continuous sexual abuse of a young child as charged in count 1 of the indictment, you must agree unanimously that the defendant, during a period that is 30 days or more in duration, committed 2 or more alleged acts of sexual abuse. With regards to count 2, even though the state is not required to prove that the alleged offense happened on the exact date alleged, the jury must be unanimous, which means all 12 of you must agree about the specific instance that is alleged to have occurred, if any, that constituted the offense of indecency with a child by sexual contact as charged in count 2 of the indictment. With regard to count 3, even though the state is not required to prove that the alleged offense happened on the exact date alleged, the jury must be unanimous, which means all 12 of you must agree about the specific instance that is alleged to have occurred, if any, that constituted the offense of indecency with a child by sexual contact as charged in count 3 of the indictment. 8, count 1. Now, if you find from the evidence beyond a reasonable doubt that in Bexar County, Texas, the defendant, Alexander Rodriguez, did then and there during a period that was 30 days or more in duration, to wit, from, on, or about the 11th day of November 2023,
So just for clarity, everybody, the fact that we just lost audio, that is from the courtroom feed, nothing that we've done here. If you don't watch Judge Boyd's court, it's not uncommon for her to just suddenly mute and then unmute, especially if she's about to cover sensitive information. So if we get these downtimes in audio, just stick with it. It'll come back. So Mrs. TCF just passed me a note that said not Ellie's fault this time, and she's correct. Ellie has definitely muted audio multiple times, but not this time. Ellie is not in the studio, by the way, today. She is off playing with her sister rather wildly. They've been going at it since about 3:30 this morning, so they've been fun. But anyways, we'll continue to hang here. Just hang tight, and if there's a prolonged pause, perhaps we'll go to another courtroom while they sort it out. But otherwise, we'll just hang tight for a little bit.
If there's any evidence of other acts of misconduct committed by the defendant against the complainant, such evidence, if any, is not to be considered by you unless you believe such acts were committed beyond a reasonable doubt. With regards to those other acts, if any, you are instructed that said evidence was admitted only for the purpose of showing the state of mind of the defendant and the child and the previous and subsequent relationship between the defendant and the child, if it does, and for no other purposes. Our law provides the defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded to the defendant, and in the event he elects not to testify, that fact cannot be taken as circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet or computer, the internet, any internet service, or any text or instant messaging service, or any social media platform, internet chat room, blog, or website to include, but not limited to Google, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, Twitter, or X, to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or other officers, or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statement of law made by counsel, if not in harmony with the law as stated to you by the court in these instructions, are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given the testimony. But you are bound to receive the law from the court which is herein given to you and be governed by that law. In order to return a verdict, each juror must agree to that verdict. But jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt, and if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you in these instructions, you will acquit him and say by your verdict, not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you are retired to the jury room, no one has any authority to communicate with you except the deputy who has you in charge. Do not attempt to talk to the deputy or anyone else concerning any question you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the deputy. Any and all communications relative to the case must be written, prepared by the presiding juror, and submitted to the court through the deputy. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, Texas. All right, ladies and gentlemen, each side will have 20 minutes to present their closing arguments to you. State.
Morning, everyone. I know you will what the judge just read for you, but I want to clarify a few things. Those are specifically about pending charges against it. I'm actually going to begin with count 3. I'm going to work my way to count 1. Okay. Count 3, as the judge read, says if you find from evidence beyond a reasonable doubt that on or about the 5th elements of all of these counts. Okay. You get elements as like a checklist. Okay, you're checking up all your boxes and make sure that everything is that you have to get anything. Okay, it's the same for your place. What I just read to you, one about 50 members of the first element, we count 3. Okay, that means was that we have to prove to you, not specifically that it took place in 53 members of the team, but that it occurred during the time period that I think this was between just second grade, she had first period. And 11, 12, somewhere around there, like she testified. That's element 1. She testified to such that. Check that box. Second element in Bexar County, Texas. She testified to several witnesses heard verified this took place at the house on Sugar Road here in San Antonio in Bexar County, Texas. You check that box for element 2. Next, the defendant Alexander Rodriguez. That is element 3. At the beginning of her testimony last week, when you saw her testify, she wrote over and pointed that that man right there is the man that did this abuse to her. That box is checked as far as element three. Next element. Did engage in sexual contact with Emily Rodriguez, a child younger than 17 years. She's 17 years old, as she testified to you today. This abuse happened between the time she was in second grade and she had her first period. That element is proven. You don't check that box. By touching part of the genitals of Emily Rodriguez, she testified several times throughout these years of abuse, he would touch her vagina. That element is proven. Check that box. With the intent to arouse to gratify the sexual desire of any person. That may be a little bit more complex than the others, but I promise you it's not, because there is no reason why anybody should touch a child in that way other than to gratify their own sexual desires. That is proven. Check that box. That count has been proven to you all on this event. Go to count 2. Now, if you find from the evidence beyond a reasonable doubt that first element on about the 14th day of November 2014, exact same way that was proven to you, same count 3. Check that box. Fair County, Texas. Exactly as it was in 1 Check that box. Abandoned Alexander Rodriguez. That element proven the exact same way as it was in count 3. Check that box. They engage in sexual contact with child younger than 17 years. 10 years before again, you check that box. New one is by touching the breast of Emily Rodriguez. Again, she testified several times throughout these years of abuse by the defendant. He would touch her breast and nipple area. That is proven to you. You check that box. Last element. With the intent to arouse or gratify a sexual desire. Again, there is no reason why anyone should touch a child in that way other than to gratify their own sexual desires. You check that box, that count is proven to you as well. Now, what's a little bit more complex is count 1, but it really isn't. I'm going to go through it with you again right now. Count 1. Now, if you find from evidence beyond a reasonable doubt that in Bexar County, Texas, the defendant, same way as in counts 2 and 3, you check that box. Did then and there during a period that was 30 days or more in duration, to wit, from on or about the 11th day of November 2013 to the 11th day of November 2017. That's the time frame that the victim testified to you all. From the time she was in second grade up until she had her first period. That element is proven to you. You check that box off. When Alexander Rodriguez was 17 years of age, he's an adult, ladies and gentlemen. He's older than 17. You check that box. Or older, commit 2 or more acts of sexual abuse. I'll get back to you guys on that one. Against Emily Rodriguez, a child younger than 14 years of age. She testified again. This happened from the time she was in second grade until she had her first period, well before the age of 14. That is proven to you. You check that box. So let's get back to that element previous. Commit 2 or more acts of sexual abuse. And you all have 3 ways to decide how those 2 acts are proven. Number 1, Alexander Rodriguez did intentionally or knowingly cause the sexual organ of Alexander Rodriguez to penetrate the anus of Emily Rodriguez, a child who was younger than 14 years of age. This is her testifying to you all that he would use his penis to penetrate her anus. Okay. Number 2, Alexander Rodriguez did intentionally or knowingly cause the sexual organ of Alexander Rodriguez to contact the anus of Emily Rodriguez, a child who was younger than 14 years of age. This is her testifying to you all as well about him touching her anus with his penis. The third one, Alexander Rodriguez did intentionally or knowingly engage in sexual contact with Emily Rodriguez, a child younger than 14 years of age, by causing Emily Rodriguez to touch part of the genitals of Alexander Rodriguez with the intent to arouse or gratify the sexual desire of any person. That is her testimony, that at night in bed, he would pull down her underwear, take his pants off, grab her hand, put it on his penis, put his hand on top of her hand, and use it to masturbate. Those are the 3 options you have. You all do not have to agree on those 3. You, sir, could think that he penetrated her anus with his penis and touched her anus with his penis. You, sir, could think that he touched her anus with his penis and he masturbated himself with her hand. You could think that he touched her anus with his penis and he penetrated her anus, And the third one as well, you could think that masturbate both times, you could think touch anus both times, you could think penetrate anus both times, it doesn't matter. So long as you all agree on at least two of those, that is proven. All three of those have actually been proven to you, and you should find him guilty on counts 1, 2, and 3. This man is supposed to be her father, her greatest protector, but unfortunately he has become the man of her nightmares. I think we'll reserve the rest of its time.
Thank you. That's
Morning, ladies and gentlemen of the jury. Good morning. It's been a long 2 weeks. I'll try and be as brief as possible, but we have a lot to get through. This is not a grocery checklist. This is not a task list. This is not a quiz. This is his life, and it's serious. This is the rest of his life. So we should treat it as such. We are going to ask that you find him not guilty on all counts. Can you play? Let's talk about what you did here. The investigation or lack thereof. Deputy Hyman, he never spoke to Emily. Child outcries September 15th of 2022. He goes to the home and talks to Clarissa. Where the hell is Emily? Your child just outcried of sexual abuse for the last 5 years? Why wasn't she home? Where was she? Clarissa didn't disclose the affair to that officer because of Roy. The only thing that deputy testified was that a crime may have occurred. That was his only task, to take contact information, address information for my client so that the police had that information. My clients lived there for as long as anyone can even remember. Let's talk about Detective Trevino. If anyone needs to change careers, it's Detective Trevino. He never went to the home. He never collected not one piece of evidence. Reminder, all the exhibits that you got, 40 plus exhibits, not one from the state. Not one. They never talked to the school counselor. That's huge. This was the first adult she told about what allegedly happened. And mind you, when Emily came back and testified, she said the only reason she said something was because the counselor went to go find her. He never talked to Emily. He testified to that. Never talked to Emily. And you know why that's really important? Because Emily got on that stand and was able to be manipulated and malleable to be able to say, oh yeah, I talked to him. She did. They implanted these memories onto her, or she just straight up lied just to be agreeable. That's terrible. That is absolutely terrible. He never reviewed the body camera footage. It just wasn't important for him. He's about to send this man to prison for the rest of his life, and he can't be bothered to review a video. He never even reviewed his own interview with Clarissa to look for inconsistencies. He never talked to the reporting officer to look for inconsistencies. He never requested CPS records. Guess who did? I did. We did. He never requested therapy notes. Guess who did? We did. He never requested medical records. Guess who did? We did. He never got school records. Guess who did? We did. He never talked to friends, family. He never talked to the teachers or principals. Some of you in here, I think, are teachers. You know which students make up big lies and which ones don't. That's huge. They know the goings on at school. They know if someone's a known liar. They know who's telling the truth and who's lying and who makes stuff up. But he couldn't be bothered to do that. They never talked to neighbors who could have heard something going on, seen something going on. Never talked to the principal. Hey, does Emily have any behavioral issues? Does she have problems with authority? Didn't matter. Doesn't matter. Never spoke to Alex's family. That is huge. These are the people that were living in the same household where this alleged abuse was going on. Why not reach out to them? He never spoke to any other potential suspects, which includes the people in the home. You know what I find very interesting? State never asked any of the witnesses, did you touch him? Did you touch Emily? Such a simple question, right? Never asked. They teach you in law school, never ask questions that you don't know the answer to. There was no eyewitnesses, no DNA, no stain exam, and he testified, yeah, victims sometimes lie. He never collected Emily's cell phone. When Emily testified, she said, yeah, we had a really good relationship. She recognized her dad's cell phone from years ago. That's his cell phone. And yeah, we called each other bra, we called each other shorty. We had a great relationship. I wanted to spend more time with him. That is absurd. That is absolutely absurd. Someone has anally raped you for 5 years, every single visit, and you want to spend more time. Doesn't make sense. He never collected Clarissa's cell phone. If he had, he would have found thousands and thousands of sexually explicit material from Clarissa sent to Alex during the middle of her marriage. He never looked for custody orders. You saw the petition that was introduced. It was there. He just took Clarissa's word for it that there was no paperwork on it. Let's talk about Clarissa. She asked Emily to keep secrets for her benefit so that she could continue this affair over the course of 4 to 5 years. She testified she couldn't remember her weekly sexual visits with Alex. You heard from multiple members of the household she'd come by every week for their rendezvous, with or without Emily. However, she also testified she would send sexually explicit photographs to him. However, she could not remember the purling. That doesn't make any sense. She didn't say, I'm not denying that he has those purling. I just don't remember. That doesn't make sense. You know that. I know that. Everyone here knows that. She testified they had the affair from 2014 to 2017. She also testified, yeah, I asked for money. Your daughter has alleged she was anally penetrated for years, and you don't care. I'll take your money. You still owe me. Give me the money. Even after he was arrested, she's still asking for money. She would send Alex updates about how she's doing. Oh, she's doing great in the orchestra. What? She goes to this school now. This is the man who raped your child, and I'm going to give you an update as to how she's doing. She misses you. She's wonderful. She's doing really great in school. That doesn't make any sense. She didn't believe that she was actually raped. It doesn't make sense. She told Alex about the abuse that she was suffering at the hands of Roy, her husband. Not just Emily, but the other kids as well. Thousands of sexual communications between the two. Thousands. And she claims that her mom faked those 2 CPS challenges and requested monthly rape kits for Emily. This was before the outcry. This was before the outcry. Someone asked for monthly rape kits of Emily. And Clarissa says it was probably my mom. She's crazy. Well, the apple doesn't fall far from the tree. Eric Mata. He denied that Emily ever mentioned camping. It happened on the same day, on the same days, same time, same place. Nothing about camping. Then when she testified in front of you the first time, she didn't mention camping. Then when we brought her back, oh yeah, it happened when we were camping and there was other family around and there was other campgoers, but he still did those things to me. It doesn't make any sense. It does not make sense. Eric said that she yelped at the pain of penetration. I don't know what the answer is here. She testified in front of you that there was no penetration. She wasn't sure. How can you convict somebody who doesn't even know if something happened or not? How can you put him in prison if you don't know? He never asked if she was sexually active or knew what a penis looked like. He never asked if she was forced to be in the room telling her story. He says that Emily that Alex tried to kiss her. She never told you guys that. She never told the DA's office that. She never told CPS that. She never told the counselor that. She never told her mom that. Emily didn't mention showering afterwards. Imagine a 6-year-old child who's been anally penetrated for years, getting up, taking a shower, and staying in the bathroom for hours. Never mentioned that. Not to him. Roy Herrera, where is he? He was subpoenaed. Clarissa confirmed he was subpoenaed for us. We wanted to hear from him. We wanted to see what kind of influence he had over Emily, but he was stubborn and didn't want to be questioned. School counselor, where is she? She was the first adult that talked to her. Where is she? The timeline. We know the pearling procedure happened in 2011. 2014, Alex moved in with his mother and the visits start happening. Alex, Christina, and Ethan are living together. She was 7. Then in 2015, Alex and Clarissa begin their affair. Again, Alex, Christina, Ethan are all living together. Then 2016, the affair continues. Alex, Clarissa, Ethan are living together. Emily is 9. 2017, I put down here, Emily gets her period. Who knows? She has no idea whether it's 2017, 2018, 2019, but somewhere in there, she's living with Alex, John Paul, and Ethan. And we know the affair keeps happening because John Paul and Ethan both testified Clarissa's coming by weekly. 2020, Alex and Clarissa end their relationship and things spiral. He meets Lisette and starts dating her, and he's still living with Alex, John Paul, and Ethan. This was when Emily's 13. 2021, Clarissa starts asking for money. They're not dating anymore, so she wants her money. She's not getting those dates anymore. She wants her money. Lisette moves in with the kids. Emily allegedly commits or tries to commit suicide. Alex, Lisette, and the kids all move in together. And she doesn't want to share a room. She doesn't want to be there. She is starting to pull away. 2022, Emily starts sneaking out, and somebody files and asks for monthly rape kits of Emily with CPS. Then 3 months later, here comes the outcry. Alex, Lisette, and the kids. CPS interviews the kids. No outcries. No outcries of abuse. And they leave the kids with Alex. Little kids. No one believes this. After the outcry, guess who's still messaging Lisette and Alex? Emily. She misses them. She wants to talk to them. She wants to see how they're doing. She gives them updates about herself and her mother. And what I find the strangest about all of this, Clarissa moves to Houston with Roy and the other kids and leaves Emily. Who does that? You have a man who is her father, who has legal custody of her, right? And you move to another city without her, without any protection whatsoever. He hasn't been arrested at that point. How protective is she as a mother? She knew this isn't true. She knows this was not true. Again, Alex, Lisette, and the kids continue to be together. In 2023, in January of 2023, the detective turns the case into the district attorney's office.
5 minutes.
Thank you, Judge. Clarissa continues in 2024 to message Lisette and Alex. Alex is arrested. Then Emily's still going on vacation with his family. None of that makes any sense. None of it. And guess who's still asking for money? Clarissa. We talked about when is it too late to walk a lie back. Emily stated, I asked, do you think you're going to get in trouble if you say you made all of this up? And she says yes. Winston Churchill said, a lie gets halfway around the world before the truth has a chance to put on his pants. The DA's office sat on this case for 1.5 years. That disadvantages us.
Improper argument, Judge.
Sustained.
Common sense. They have the burden of proof. You can find somebody guilty based on the testimony of one witness, but that one witness has to be credible, and Emily is not credible. Remember the standard of proof. They have to prove every element beyond a reasonable doubt. And remember, to terminate your rights as a parent, it has to be clear and convincing. If it's not enough to terminate your rights as a parent, which obviously it wasn't for his rights were never terminated, then it's not enough evidence to take his freedom for the rest of his life. The inconsistencies. Emily said it was every other weekend in the same room, same time and place. And then years later, she says, oh, actually, we were camping. She claimed she felt something wet on her back, and then later claimed she actually smelled it and tasted it. Then she said the abuse started at 5. Oh, maybe 6, maybe 7. It stopped when I was 10, maybe 11, maybe 12. She claimed she was anally penetrated, then changed her mind and said, no, I don't think it was. I think it was only contact, but no penetration. But we know there was no signs of penetration. We know there was no staining. There were no tears, no blood. No emotional changes at the time of the alleged abuse. Nobody knew anything was happening. She said she was pretending to be asleep. So she had her eyes open and closed. She told CPS she was asked specifically by CPS during this time, is anyone touching you? No. She was asked by her mom, is anyone touching you? No. She told his mother, Alex's mother, she felt guilty and that she still does to this day. You do not feel guilty about something unless you've done something wrong. She never mentioned the beads. It's reasonable doubt. There's no physical evidence. There's no eyewitnesses. There's no signs of abuse. Clarissa has a motive to lie. She manipulated Emily. Emily's testimony is unreliable. Look at these messages. Is this someone who has been sexually abused? I want to see more of you. You're the best dad in the world. Nobody forced her to do that. Nobody forced her to do that. Read those messages. If at the thought that you had when the state rested their case, is that it? Is that all it takes for you to be charged with a crime? Is the word of an emotionally disturbed child? That is pretty scary because any one of you could be in this situation. There's no evidence against Alex. This defense put on 40 plus exhibits and the state put on 0. Not guilty does not mean you don't believe something happened. Not guilty doesn't mean I think Emily is lying about everything. It doesn't mean that Alex is a saint or that he's gonna even get custody. It does mean that the state didn't prove each and every one of their elements beyond a reasonable doubt. It does mean that you upheld your oath. You swore and you took an oath to follow the law. And if you have doubts, and I know you do, then your vote should be not guilty on all counts. If you go back to the jury room and you think to yourself, I don't know who's telling the truth or who's lying, I don't know what happened, then it's simple, not guilty. I want you to look at the verdict form in the back. Not guilty is up the top on each count of 3 counts. You choose a presiding juror, they sign at the top, and we end this ridiculous trial and nightmare for Alex. Thank you very much.
State's at 13 minutes, 11 seconds.
Thank you, Judge.
I felt guilty. I felt guilty. I wish I had talked to him about it. I felt scared. I thought you were afraid of him. I was. Parts of him. There were good parts of him too. I felt guilty. Like I was ruining his life, like it was my fault. Members of the jury, you never want to hear a child say what Emily said. You don't want to hear it because you know it's true. You know that even after everything her father has done to her, she loves him. Even after all the years of molestation and sexual abuse, she loves him. Even after getting called a liar, she loves him. And I'll bookend that with the testimony of the very last person you heard from the defense, Deanna. Defense asked if Emily was malleable, right? That was the defense's word, malleable. And Deanna said, I wouldn't say malleable. And Deanna noted 2 things after that. She said that Emily was concerned with hurting someone else's feelings. And she said that Emily will feel really bad if she thinks she's hurt your feelings. Did you hear that in the trial? You bet you did. Repeatedly, I felt guilty, like it was my fault. And she couldn't even raise her voice on the stand. The same kid that would go to an HEB, remember the testimony of Ethan, and stand zoned out at the milk, right? That's the same kid you saw on the stand. In fact, in line with not raising her voice, this is a kid that didn't feel like she had a voice. She didn't have a voice, so she tried to kill herself. And notice during the defense's cross-examination, there was a lot of discussion, right, on the exact day that she attempted suicide, right? The exact day. Was it the same day that you talked to the counselor? No, not the same day. You told ChildSafe it was the same day. No, I don't remember saying that. Not the same day. I never told someone it was the same day. I didn't try to kill myself that day. Members of the jury, that's the when. The when, right? So in the who, what, when, where, why analysis, we all agree on the who, the what, the where, the why, and we really almost agree to the exact day on the when. You know what that tells you with respect to the attempted suicide? That it happened. But go with me here. With respect to the attempted suicide, the whole time she's talking about that, I think the parallels became very clear and twofold. One, the lack of specificity with the date as it relates to both her attempted suicide and her first period. Okay? This is a girl that struggles with the exactitude of dates. This is not a girl that struggles with the clarity of the memorability of those events. You know what is clear? She attempted suicide. You know what else is clear? That when she got her first period, her father stopped sexually abusing her. Those were clear. And the second parallel between those 2 events, right, is that the defense had to, again, attack the minutia or specificity in order to detract from the truth, right? Defense, so it was every weekend? No, almost. So it was all the time? No, almost. Emily said he would say my name or talk to me. He would check to see if I was awake. You never told anyone he would assault you during the alleged assault. No, not during. Beforehand, sometimes afterward, to see if I was awake. And I'm not splitting hairs. I am not splitting hairs. Almost every weekend is not every weekend. Talking to your daughter before or after is not talking to her literally while you're in the act of assaulting her. Those are two different things. And she was clear on that from start to finish. Now we're going to dive into the defense counsel arguments here. But first, remember in voir dire when I discussed the rules of football? You remember that? I did that because I knew I'd be spending the majority of my time in this trial objecting. I know how they argue. You saw that. You remember during voir dire 2 when I was talking about the Sabrina Carpenter, the coffee example with jury number 52? I knew they would spend a majority of their time in this trial trying to muddy the waters, even with the non-victim witnesses, right? So remember Eric Mata, remember the forensic interviewer? He got on the stand. What about the camping trips? What about the mother? What about the affair? I don't know. We never discussed that. I don't recall. You don't know? You never discussed that? You don't recall? Finally, Eric, a grown man, you watched it. He put his hands up and said, I'm sorry, I'm not trying to be disrespectful. I don't know what you're talking about. That's what he said. Does that remind you of anything? It's coffee. It's coffee. It's coffee. It's almost like I knew what they were going to do. That's how they argue. Now, some of these defense counsel arguments, you just heard counsel talk about the fact that Emily didn't tell her mother everything. They just said that. She doesn't know the full extent. She's learning the full extent right here, right now. With respect to Eric Mata, he was able to testify as to the things he heard because the victim specified with clarity the things that happened. That's why I was able to ask him on the stand, what did she say? What did she tell you? Right? The law provides that opportunity for him specifically because he can testify as to the specificity that she relayed. I didn't have that opportunity with other witnesses. I had it with him. That's the opportunity that the law provides me. So, yeah, counsel talks about the 42 exhibits, whatever number. Yeah, look at those pictures of SeaWorld. Okay, look at the pictures at the theme park. What do you expect this kid to do for 4 years? Hide under a blanket? Is that what you want? What do you expect? We talked about in voir dire how kids react differently. We talked about it for that exact reason. It's always the photo of SeaWorld. Oh, and she would text him and write him Father's Day cards. Again, what did you expect? That's why we didn't even object to those coming in. The photos themselves are a disgusting enough notion. We talked about that, right? I went through it. Daylight, people there. I did all that in cross-examination. We already talked about that. But the letters, does that not make perfect sense for a kid that loves her father? A kid that doesn't want to hurt anyone's feelings? In fact, this is actually somebody, she has no problem hurting herself, right? But it's others that she cares about. What was she supposed to do? So if she's a good student, well, nobody ever noticed any issues, so she must be lying about sexual assault. She had bad grades? Well, you had bad grades, so you were mad at your father about something, so you made up sexual assault. Either way, that's how they're going to paint it. Other people lived in the home with paper-thin walls. It's always the paper-thin walls, right? So thin you could hear someone put their socks on. I asked that ridiculous question. He backed off on it. But that's my first question was, so thin you could hear someone put their socks on? I mean, yeah. So someone that said they wouldn't lie for the family, but you can hear socks being put on in another room? Okay, that's incredible. That's incredible testimony. Another defensive argument was the lack of DNA or physical evidence. This was a years-long delayed outcry. Years, right? This is what we talked about in voir dire. This is why Detective Trevino said repeatedly, you're not going to get evidence after 120 hours. This wasn't a 120-hour delayed outcry. It wasn't 120 days, right? It wasn't 120 weeks. This was years and years and years. Until finally, she told the person that she thought couldn't say anything. Remember when she testified? She only told the counselor because she was under the impression that that person couldn't say anything. Does that sound consistent? Like someone that doesn't want to hurt someone's feelings? The girl that somehow still loves her father, that raped and molested her, the girl that doesn't have a motive to lie? Let's get into motive. She didn't have a motive back then, right? There's no nasty divorce with the $1 million home, right? There's no real custody issues at all. Plenty of testimony after the period. He took her there. That's all contextual. There's really there's no haranguing. There's no mistake, no problems, no divorce, no custody issues. Things just kind of seem to be a handshake agreement.
5 minutes.
Really no problems. Now, the defense can posture that Emily was receiving pressure from her mother, but Deanna Wood, their own witness, said again that her impression of Emily was that she was not malleable. She went on to say that she herself did not see any pressure or power of the mother over Emily. That's their witness. Eric Monta noted that she didn't appear to be under any external pressure or influence. And then he provided the additional context. They child safe, they screen for coaching too. That's what forensics do. That's what he's done for over 2,500 forensic interviews. This is what he does. If she had a motive to lie, then just say his penis went inside you. You're almost all the way there. You yelped and felt pain. I'm telling you, if you have a motive to lie, just go all the way. Why stop there? Why? And if you really have a motive to lie, just say it happened every single time you went over there. My God, wouldn't that be easier? Not almost, not correcting, almost every time. Every time, almost. If you're really gonna lie, God, just make it simple. Make it a binary. Every time I went over there, I was raped. Every time? Yeah, every time. Yep, every time. Simple, every time. If you have a motive to lie, that's what you do. And if you have a motive to lie, just say you were facing him. Don't speak to the truth of the fact that he would whisper behind you. He's the only one that ever went into the room. You knew it was him. Just lie and say, yep, looked right in his eyes every single time he molested me. If you have a motive to lie, just do it. Just take it all the way. Why are you stopping there? She doesn't have a motive to lie. There is no motive to lie. The mom's pressure over her, for what? To what end? What are we doing here? There is no motive to lie. She didn't back then. She doesn't now. She didn't not once. And I got her words myself, right? Remember when they called her back up again, I drew the timeline on the board right here, right? I put the X second grade to the time that the period happened. And I wasn't sitting in between the tables, right? Remember the first time I sat between the tables, I'm asking her questions. What happened? Tell me about this. I stood literally where I'm sitting there. I put a marker in her face and I say, don't just tell me what I want to hear. Second grade? Was it first grade? Was it third grade? It was second. Okay, well, did it happen when the abuse stop when your period happened? Were you 10, 11, 12? Don't just tell me what I want to hear. I've never spoken to a child witness that way. Don't just tell me what you think I want to hear. I almost yelled it at her. You guys, I was standing right there. But I had to do that. I had to yell at her. I had to put the marker in her face. I had to draw the line. I had to say all those things because when you go back there, I want you to know that she's the same quiet girl. She's consistent, even when it's me that's yelling at her. And if she was the same girl without a motive to lie. We had the sensory details about wet and hairy. Eric Mata told you about the importance of those details. But then you go to the consistency and cooperation across the accounts. And I kind of drew that grid yesterday, right? You have what she told CPS. You had what she told the forensic interviewer. You had what she told the DA's office. We have the testimony where Detective Trevino, right? He's the 30,000-foot guy, sees everything. Clarity and consistency across all the accounts. There's actually some testimony about the therapist. It was very brief, but the therapist in his discussion with the detective, where he said she was consistent in her outcry, even with the therapist years later. She got on the stand Thursday. She got on the stand yesterday. So that's 7 different accounts across multiple years, across multiple people, and it's the same story every single time. It's the same account. It's the same retelling. It's the same details. It's the same person. With respect to count 1, continuous sexual abuse of a young child, you're going to see it right here, like Rick pointed out to you. You're going to see count 2, indecency with a child by contact, and you're going to see count 3, indecency with a child by contact. Given everything we've talked about, her true motive to lie, the fact that she was clear and consistent across those 7 accounts, across all those temporal dimensions, across all those time periods, across all those people, we're going to respectfully request a verdict of guilty. Thank you.
All right, ladies and gentlemen, you've heard all the evidence in this case, and Deputy Laura will take you to the back.
All right, well, there you have it, folks. That's the closing arguments. Poll looks like 17% of you believe guilty, 42 not guilty, 42% unsure. Yeah, I don't know that there was a... I mean, obviously, I didn't watch the whole trial. It's very hard doing this channel to watch entire trials, but Bailey, I know that you watched it, and my impression based on what I read in the chat from you is you probably thought that the prosecution dropped the ball and this was a not guilty. If I'm reading what you said wrong, let me know, but that's kind of what I gathered. But we'll keep an eye. If we get a verdict here shortly, we can cover it. If not, we can bring it up tomorrow. Put a 1 in the chat if you want to go into overtime for a few minutes today, or if you want me to just say goodbye at 9 o'clock and let you go on about your way. Let me know. In the meantime, let's go back to Judge West. That's a good place. Let's do that. Let's make that happen.
615 for the offenses of escape while arrested, assault on a peace officer, and possession of a controlled substance. There's been motion to revoke filed in all 3 of those cases. And Mr. Nix, what is the announcement?
Your Honor, I've spoken with the state. I think we have something in the works. I think we'd both like a 2-week reset. And I think in 2 weeks, some offers that we made to the state to try to resolve these issues will be made whole at that time. And I think this will be worked out at the 2-week reset.
Any issue, Ms. Malfino?
Judge, I have spoken at length with Ms. Johnson, who has worked with this defendant for a long time now. Of course, respect her position ultimately in that she is the one who actually works with her. There are quite a bit of arrears due in this case. Ms. Broussard has been ordered previously to pay those with forms of income such as her tax return, etc. She has been defiant in doing that to the probation department. Mr. Nix indicates that she, via her family while she remains in custody, is able to do that in the next 2 weeks, and I'd like to reconvene at that time to maybe see where we are. Our position in the alternative will probably be ISF cognitive. In fact, if she does not get that paid, we may just go ahead and proceed with the motion. We'll be ready to do it on that day.
Okay, sounds good. Thank you for being here, Ms. Johnson. We'll reset the case for 2 weeks.
Thank you, Judge.
Thank you. Ma'am, you need to remove your hat, or you need to remove your hat. Or sir, I can't tell, I can't see your face, whoever.
Check your phones, make sure that they're in off position.
See, Mr. Thank you. Mr. Burbank, you've got Jerry Jenkins.
Judge, before we bring them out, maybe just discuss it.
Yeah, let's hold on.
All right. Well, what Judge West has gone quiet. Let's go to Judge Middleton. It looks like he's got somebody in the jail that he's speaking with.
Hello?
There we go. Good morning, sir. Are you William Raymond Duzinkus?
Yes.
Is that how you say it?
Yes, Zinskas or doesn't.
All right. Well, the file number here is 25960. You're charged with 2 counts of resisting obstructing a police officer and disturbing the peace. Those first 2 are felonies punishable by up to 2 years imprisonment and a fine of up to $2,000. The last count, disturbing the peace, is a misdemeanor punishable by up to 90 days in jail and a fine of up to $500. The prosecutor has agreed to dismiss all of those charges if you plead to attempting to resist, obstruct a police officer, which is a misdemeanor.
Yes.
That's a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000. Let's take a look at your complaint here. This happened 16 days ago on May 25th. It's alleged that you did assault, batter, wound, resist, oppose, or endanger Sergeant Aaron Moore
and Sergeant or Officer Joshua Wired of the Sturgis Police Department. This happened at some stores in Sturgis. Do you understand the charge?
Yes, Your Honor, I do.
Are you going to plead to that lesser misdemeanor charge of attempting to resist or obstruct a police officer?
Yes, Your Honor.
All right, well, let me tell you this. A couple things that you need to know. If you do plead guilty to a felony charge, you give up your right to have a trial in front of a judge or a jury. There will not be a trial. Do you understand that?
Yes, Your Honor.
If you had a trial, you'd have the right to be represented by an attorney. Mr. Gibson is here with me in the courtroom. Could also hire an attorney of your own choosing if you wished. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would have the right to take the witness stand and testify on your own behalf. But you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. You understand all that?
Yes, I do, Your Honor.
All right. Now, other than this plea agreement where they're dismissing these felonies for the plea to the misdemeanor, did anybody promise you anything to get you to plead to this?
No, Your Honor.
Or threaten you?
No, Your Honor.
Now, you were in Sturgis on this night, which is May 25th. Had you been drinking?
No, I don't drink and I don't eat drugs, Your Honor.
All right, well, it says here you look like you were on the way from Minnesota to Ohio, just passing through here. Is that correct?
Yes, I walked, may I speak? Is it okay, Your Honor?
Yeah, go ahead. Tell me what happened.
I left Minnesota about 128 days before this because it wasn't working out to get my ID. And I had to fall out with a friend. And so I walked through Wisconsin up to the Upper Peninsula, down to my non-extraditable in Indiana. The whole mission was so I could get.
That's a long way from there to here. You walked all that way?
Yes, sir. I mean, I've had rides from troopers and, law enforcement and some good people. I was just attempting to find an address for people I knew down in Kalamazoo, and it didn't work out. So I went into Michigan City and got my ID, and I just want to get back to work. So I was walking through Sturgis to get to Coldwater. So my friend Joey from Indiana, Fort Wayne, would come and meet me with my hard copy so I could get my ID and get, glasses and Medicare and stuff.
Well, here's what it says. You had a black Dude Abides t-shirt, dreads. You were in a store and they called and said, hey, this guy's threatening us. So they came and you kicked the entry door open and you were spitting on cars and knocking trash cans over. What were you upset about?
People were behind me, I get nervous or anxious, and then then my reality, I get blurred. But I turned around and I said I had PTSD. I looked at the counter. I was explaining to them that I didn't mean none of this, that I deal with schizophrenia and PTSD, and I just wanted some cigarettes. And I picked up the trash can too, man. I know they don't have that in the report, but I picked up the trash can. And I can't explain, I don't understand why it wasn't sitting or following commands by the same people I honor, man. So,
all right, so then you kind of struggle with the cops and then they tased you a couple times. That probably wasn't fun. And then they took you to jail, correct?
Yes, sir. Yes, Your Honor.
All right. Mr. O'Bear, anything else you think I should know?
No.
You must be in awful good shape if you can walk from Minnesota through the UP to Sturgis. I just finished a book that was set in the Upper Peninsula in January. So you were walking through the UP like in the wintertime?
Oh, yes. I got caught in an ice storm a couple times. I made it though. I got down to Kalamazoo, and the person I knew, I guess I didn't know him that good because I only spent a night on their couch. He wound up swinging on me, and I left a bunch of stuff in his house that got stolen from me once he locked the door. I didn't hurt him or anything. I just didn't want to be hurt. I went back up to Marquette with somebody I met. She wanted out to be bat crazy. And so I just said, I'm gonna go down into Indiana myself to get my ID so I can get to work. That's all this has been.
What is for you in Ohio?
Just a new beginning, I guess, somewhere where.
I encourage that. I'm gonna give you 0 fine, $75 crime victims' rights fee, and a $50 state minimum fee. You were a huge pain in the neck and scared the people in Sturgis. I'm gonna order 30 days jail, credit 16, 14 days to do, $125 or 2 additional days. There's 5 days a month added to that as good time or reduced from that. You got about 8 or 9 days to do here, and then when you're released, you should be free to go on about your business. So good luck, sir.
Are you asking for restitution in that one, Josh, though, for the
Thank you, guys.
No, I'm not gonna order any restitution. Simply, hello, Deputy Ross. How's it going over there?
All good.
All right, good luck, sir.
All right, let's go back to Judge West, and we'll see what's going on there for a little bit, and then probably call it a day.
Good morning. Are you Terry Rose?
Yes, ma'am.
And Mr. Rose, in cause number 241369, is charged with the offense of murder. There was a request for a competency evaluation that was done by Dr. Grapon. I'm going to take judicial notice of the court's file. We have received that evaluation dated May 23rd of 2025. Dr. Grapon, after that evaluation, makes the finding that Mr. Rose is currently competent to stand trial. Is there any other evidence with regard to competency? Mr. Burbank?
Defense, Judge. No, Your Honor.
Then at this time, I am going to find that Mr. Rose is competent to stand trial. Mr. Burbank, announcement?
Your Honor, as you are well aware, I'm the second one.
Right.
I just need one more announcement, 30 days or 40 days, and we may be able to.
Okay. Any issue with that, Mr. Nichols?
No, Your Honor, we're just, state's ready to proceed.
And I appreciate you getting up to speed as quickly as possible. Looks like we've got an investigator involved and you've taken care of that.
We do,
So,
and I was out, I provided him information, and he's helping me with this, and so once I cover all my bases and get up to see the district attorney, we'll be able to take care of this now.
all right. What I'll do to make sure your investigator, you have plenty of time to get up to speed, is reset it 45 days and expect an announcement on that date.
Thank you.
All right.
Maybe
Thank you.
excused to that time.
Yes, sir.
Thank you, Judge.
Do you want to go ahead and take care of Bryce Thomas and then visit? Okay. Bryce Thomas.
So while we wait for the next contestant, I once again risk destroying the world as I cross the streams, but I want to. And we know that from Ghostbusters, of course. But I want to point out that as of yesterday morning, so running about 26 hours now, we have here on the channel a 24/7 Judge Fleischer stream going. I can't make him stream his court anymore, but I can show you his old stuff. And we've got 40 hours that are currently looping and about 120 more hours that will be added in the coming days. So be sure to check that out. If you like you some Judge Fleischer, it will always be there, at least until somebody tells me that I can't do it. We'll keep it running. And if you stick around at the end of this stream, YouTube will actually send you right over there. So anyways, just thought I'd point that out. Enjoy. Let's go back to Judge West.
Client waive the formal reading of the indictment in each case.
Yes, Your Honor. we're going open on each case, and the aggravated sexual assault is being the lesser included indecency by exposure, which is a third degree.
So is,
Did you sign it? Did not.
we can do it, y'all can get it done as soon as I'm finished. I'll go,
Completely about the registration.
I'll go through it with them. I just want to make sure, because of the agreement for the lesser in that case and for anything to run concurrently, is that the plea bargain agreement where he would be waiving his right to appeal?
And also
The dismissal.
the UUMB.
Gotcha, okay. Give me just a second, yeah.
And the lesser included is instead of a first, is a
Third. Oh, 0354 has been dismissed, I think. Or 0534, whatever I said. Okay, Mr. Thomas, in cause number 24, DCCR 0389, you're charged with a third-degree felony offense of possession of a prohibited weapon from January 31st of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? In cause number 24-0390, you're charged with a third-degree felony offense of possession of a prohibited weapon from January 30th of 2024. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? In cause number 24 DCCR 0391, you're charged with a state jail felony offense of theft of a firearm, and that's from January 30th of 2024. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? And then what is the reduction to?
It's indecency exposure, third-degree felony.
In cause number 24, DCCR 0392, the state has elected to proceed on the lesser included offense of a third-degree felony of indecency with a child by exposure, and that's from November 9th of 2023. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And because you did what they charged you with? In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Burbank? Do you fully understand them? And I want to make sure you understand there's kind of a partial agreement, and that agreement is that the state is going to dismiss cause number 24-0534, which is an unauthorized use of a vehicle. They are agreeing to that lesser included offense of the indecency in that case, and they're also agreeing that if anything that I sentence you to, if it's time in prison, would run concurrently. There's not a specific agreement with regard to any time or any outcome, only those agreements with regard to the dismissal of the case, the reduction in the other case, and the fact that they'll all run at the same time. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Also, in that indecency case, do you understand that you will be required to register as a sex offender? And Mr. Burbank will go over that more with you today, and there's a document you need to sign today with regard to that. And do you understand that as well? State tenders number 1 in each case.
No objection. States one in each case, Your Honor.
It's admitted in each case. Is there any evidence that Mr. Thomas is not competent?
No, Your Honor.
All right, sir, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each of your cases to find you guilty. However, I'm going to reset your case for a sentencing hearing. We'll get a pre-sentence report done. That'll give me more information about you, your cases, and we'll come back later for sentencing. Anything that you think is important for me to know, make sure you get that information to Mr. Burbank. He will present it to me on your behalf when we come back. All right? You can go back with the bailiff.
May be excused from that.
Yes, sir. And I'll give you a minute to talk to
Can
Mr.
someone
Ramon.
Send it back to a computer.
Send what back?
I think you have to send back so I can do the admonishment for the section.
I think we should just go ahead and leave it there for today. This has been a heavy day. What, a couple of assaults against children. We got a murder in there. Not a lot of light stuff, that's for sure. But sometimes that's how it rolls here at TCF. But nonetheless, I hope you all enjoyed yourselves. I know I did, and I know Mrs. TCF did. She's shaking her head yes, so maybe she'll come back and join us tomorrow again too. You never know. Do me a favor, if you have not already, please do smash, or as Michael Groff likes to say on his channel, lightly caress the like button. Massage it a little bit, whatever it is that you do to like buttons without being weird. Please do that for me, please. And if you're not already, certainly subscribe to the channel. And if you are subscribed to the channel, do consider becoming a channel member for a couple reasons. Number one, you get access to the pre-show, which I think is all sorts of fun personally, and people keep showing up, so it must be all right. And as well, that money is what funds the continued improvement on this channel. Like that's what is able to bring us that Judge Fleischer 24/7 stream, for example. So if you want to support the channel and not spend a whole lot of money doing it and get a couple of extras, that's how you do it, and it's very much appreciated. So we will be back tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour earlier for channel members. In the meantime, go have yourselves a great Tuesday. Take care and God bless.